question has to be resolved in the courts, and by my state and many others, that's the first time we've ever faced anything like this.
But you wanted Clarence Thomas to recuse himself. He has not.
He should. I think he should have. And for the good of the court and the reputation and integrity of the court, there's no question that his wife was uniquely positioned in the political debate on election denial. I think it would have been in the best interest of the court and their reputation for him to step aside.
Could they rule fairly?
Pardon me?
Do you think they could rule fairly here?
That remains to be seen.
And just on the Ukraine piece of the packet supplemental here, what is your expectation as we head into the next couple of days and your level of concern that this all could collapse?
I'm very concerned. Let's be very honest about this. Ukraine's future is hanging in the balance here as we involve ourselves in political debate in Washington. Many of us are supposed to attend the Munich Security Conference in a week, and that has been an effort to try to unify and organize the effort to defeat Vladimir Putin. What are we going to tell them if we've decided here that the United States is not going to support the Ukrainian war effort? I don't know that there's a good answer, but I'll tell you, the future, as far as I'm concerned, remains in steady support of what the Ukrainians are doing, courageously doing to fight off Putin's advances.
What's your reaction to Republicans wanting to make amendments at the last minute?
This is MAGA week on Capitol Hill. Did you notice what happened in the House? Mayorkas was supposed to be impeached, and that failed. Then aid was supposed to be sent to Israel, and then that failed. And then James Langford, for goodness sakes, at the direction of his own caucus, spent 4 months negotiating a border plan, which was rejected at the last minute because Donald Trump announced publicly that he was opposed to it. This is the MAGA world on Capitol Hill, front and center.
And how is that going to play in November?
I hope the American people are paying attention. We're wasting so much time on political errands for Donald Trump and not spending time on things that American families really count on us to do.
It seems like Republicans are asking for amendments on border provisions specifically.
Listen, you're all political observers. What they're trying to do is to overcome the embarrassment of yesterday when the border plan, the bipartisan border plan, was rejected by virtually all of the Republican senators. Now they want to put Democrats on the spot, tough vote, thinking that they've evened the political ledger. The bottom line is nothing's getting done. We need to do something now. We had a bipartisan approach to it. The president was on board. We were ready to pass it, and the Republicans walked away from their own plan last night. Why? Donald Trump told them to.
Do you think they could reverse Biden's numbers in terms of immigration?
Well, I'm not going to say what's going to happen on any numbers, but this I will say. The American people are watching, and eventually they're going to tune into the reality that a MAGA world on Capitol Hill in Washington will be a disaster.
Thank you so much, sir.
When I went to college here in Washington at Georgetown, I used to come into this Capitol building and sit up there where our visitors are now sitting and watch what was going on the Senate floor. I can remember so many things, particularly the day that Bobby Kennedy gave a speech about Vietnam that was highly anticipated. He came walking through that door with his brother, Ted Kennedy, both of them senators, one from New York, the other from Massachusetts. It was a historic moment. It was a magic moment. For a college student, it was just overwhelming to be a witness to that history and to realize what this chamber has meant to this nation, what this building has meant to this nation throughout our history. That's why I'll never forget what happened in this chamber on January 6th, 2021. Violent extremists stormed the Capitol to prevent certification of the 2020 presidential election. Donald Trump was engaged in the big lie. For the first time, really, in the history of the United States, he questioned the legal outcome of an election. Madam President, you and I both know that is fundamental to a democracy, the belief that we can have the peaceful transition of the decision makers guided by the people of this country without political interference. As insurrectionists ransacked this building, many carried flags and banners to show their support for former President Trump in his effort to overturn the election, the big lie. Two of the more prominent symbols of the so-called Stop the Steal campaign on behalf of President Trump were on display that day. One was an American flag flown upside down, and the other a so-called appeal to heaven flag. While the events of January 6th were hard to imagine, reports that these same battle flags flew outside the Supreme Court Justice Samuel Alito's home were nearly as shocking. In January 2021, less than 2 weeks after the insurrection at the Capitol, an upside-down American flag flew over Justice Alito's front lawn in suburban Virginia. In the summer of 2023, the appeal to heaven flag flew on the flagpole of the Alito's beach home in New Jersey. While these flags may have once held other meanings, in the year 2021, they were closely associated with election deniers and extreme right-wing politicians. They are, in fact, the battle flags of Trump's MAGA movement. The Supreme Court's authority, Madam President, ultimately rests on its reputation and public confidence. The Supreme Court doesn't own an army. It doesn't have a vast treasury. It depends on people trusting the justices to make honest, professional decisions. This reputation and public confidence is the strength of the Supreme Court. That is why the Supreme Court's recently adopted Code of Conduct requires justices to avoid impropriety and the appearance of impropriety in all activities. And both the Code of Conduct and federal law require justices to recuse themselves when their impartiality might reasonably be questioned. The flying of these flags marks a new, disturbing chapter in the Supreme Court's ongoing ethical crisis. It suggests that Justice Alito has not only chosen sides in an ongoing political dispute, but he's also announced his allegiance in pending legal disputes. As we speak, the Supreme Court is considering two critical cases relating to the 2020 presidential election and the January 6th insurrection. In Trump versus the United States, the Supreme Court will decide whether former President Trump is immune from criminal prosecution for his efforts to overturn the election. And in Fisher versus the United States, the court, again, the Supreme Court, will determine whether the federal felony obstruction statute applies to the January 6 rioters who tried to stop Congress from exercising its constitutional duty to certify the election. The court's ruling on these issues will be critical to ensuring that those responsible for one of the darkest chapters in our history are held accountable. But displaying the upside-down American flag and appeal to heaven flag creates the appearance that Justice Alito has already aligned himself with the Stop the Steal campaign. He cannot credibly claim to be an umpire calling balls and strikes in these cases. He has donned the jersey of his favorite team. That's why I called on Justice Alito to recuse himself, and why I urged Chief Justice Roberts to finally step up and take the steps necessary to ensure that Justice Alito does not sit on those cases, and rather that he recuse himself. Last week, Justice Alito refused my request. I'm going to keep this letter. The original version was sent to me and to Senator Whitehouse by Justice Alito, in which he makes an argument that these flags should not be taken seriously, that it was his wife's decision. There were complications in her decision. It's hard to accept this. It's hard first to believe that this man whom we're asking to recuse himself from these Supreme Court cases has somehow stood in judgment of himself and decided that he did nothing unethical and should not recuse himself. He refused our request to come before the committee and refused our request to recuse himself from these cases. In doing so, he claimed he bears no responsibility for the January 6 related flags flying over his homes. Instead, he placed the blame solely on his wife. He went on to downplay the significance of the upside-down American flag display, claiming it was part of a dispute with his neighbors. And he denied knowing about the connection between the appeal to heaven flag and the January 6th insurrection in the Capitol. Chief Justice Roberts likewise refused my request to take action and simply deferred to Justice Alito's decision. But Justice Alito's refusal to recuse begs the question, why should he have the sole power to decide whether his recusal from the case is necessary? Additional reporting has also already called into question his version of events, with text messages and even a recording of a call to police suggesting the neighborhood dispute occurred after the upside-down American flag flew over the Alito residence. And whether Justice Alito raised these flags himself or stood idly by while his wife did so, the fact remains the same. A reasonable person would question Justice Alito's impartiality to cases relating to the 2020 election, and January 6th recusal is therefore necessary. But the consequences of Justice Alito's actions go far beyond this. He needs to recuse himself from these cases. By displaying two symbols of the MAGA Republican movement, Justice Alito presented himself to the world as a political actor and an ally of the far right. His actions suggest that no matter what arguments are made or what evidence is presented at the Supreme Court, his decisions will align with his personal beliefs and policy preferences. And no matter what excuses or explanations he provides, now or in the future, it will be hard for anybody before the court to believe that Justice Alito approaches their case without bias. We cannot afford further erosion of public confidence in our courts. Our faith in the impartiality of judges is essential to the functioning of our legal system and our democratic form of government. For more than a year, story after story has broken about ethical misconduct by the sitting justices of the Supreme Court. We've learned that some justices, including Justice Alito again, accepted gifts and travel from billionaires with interest before the court. The Senate and the American people deserve to know the full extent of how immense wealth is used to buy private access to the justices. That's why the Senate Judiciary Committee is exercising its constitutional authority to investigate what has been provided to the justices. And I will continue to push for legislation, a bill sponsored primarily by Senator Sheldon Whitehouse, but many of us have joined as co-sponsors, to establish a binding code of conduct and recusal standards for the justices. Why in the world should the highest court in our land have the lowest standard of ethics? If every other federal judge is held to a standard of ethics to make certain that their reputation is intact, why would that not apply to the justices sitting on the highest court in the land? We'll continue to push for legislation to create a binding code of conduct and recusal standards that the American people can see. Last year, the Judiciary Committee reported to the floor the Supreme Court Ethics, Recusal, and Transparency Act. Importantly, this legislation's ethical and recusal requirement would apply equally to every justice of the Supreme Court, regardless of the party of the president who appointed them. The Supreme Court has failed to act to address the ethical crisis that has engulfed it, and the Senate must do so. Madam President, there's a simple fact. There is a Chief Justice of the Supreme Court, John Roberts. It is within his power to resolve this ethical issue tonight, to have it done by the morning, to make it clear that the Supreme Court is taking a different course, one that is credible to the American people. Justice Alito cannot stand in judgment of himself. The fact that we have to come to the floor of the Senate to plead this case makes it clear that there are no avenues to be followed for ethical consideration before the court today. That can change. The bill that is pending on the calendar is a step in the right direction, and I totally support it. I close by asking unanimous consent that the letter sent to me by Justice Alito be part of the congressional record.
Without objection.
Madam President, I yield the floor and suggest the absence of quorum.
Clerk will call the roll.
Mr. President, one other topic of importance. For more than a year, story after story has broken about the ethical misconduct by sitting Supreme Court justices. We're talking about the highest court in the land, the 9 men and women sitting on the Supreme Court, who are not governed by the same rules of conduct and ethical standards as every other federal judge in America. They want special treatment. Justice Clarence Thomas has been at the center of many of these stories. For decades, he has accepted lavish gifts and luxury trips from a gaggle of fawning billionaires. The total dollar value we estimate for these gifts accepted by Clarence Thomas, by and large never disclosed, is $4 million. Get that. Supreme Court justice, highest court in the land, life and death decisions every day, and he's receiving $4 million in gifts that he doesn't disclose. Justice Thomas has failed to disclose the vast majority of these gifts in clear violation of financial disclosure requirements under federal law. Late last week, another story broke. I'm hesitant to raise this story because it involves Justice Thomas's spouse, but I can no longer avoid the obvious. She is a political activist, and her activism raises serious ethical questions. According to public reporting, Justice Thomas's wife, Jenny, sent an email to Kelly Shackelford, who runs the First Liberty Institute. This right-wing organization, which is on the advisory board of Project 2025, which we're learning more about, frequently litigates before the Supreme Court and strongly opposes Supreme Court ethics reform. In her email, Clarence Thomas's wife, Jenny, thanked the organization for its opposition to court reform, ethical reform, writing all in caps, quote, "You guys have filled the sails of many judges. Can I just tell you, thank you so, so, so much." When asked about her efforts to overturn the 2020 election, Jenny Thomas told Congress that she and Justice Thomas just don't discuss each other's work. That's a little hard to believe, isn't it, when you see this missive that she sent to this organization. Her comments on behalf of judges create a clear appearance of impropriety for Justice Clarence Thomas. Accordingly, I've called for Justice Thomas to recuse himself from any future case involving First Liberty Institute. This is not the first time that Jenny Thomas's actions have raised serious questions about her husband, Justice Clarence Thomas' ability to fairly hear cases before the Supreme Court. Jenny Thomas is a political operative who regularly works with right-wing groups on issues being litigated before the court, and it isn't a volunteer work in many instances. She is a political operative who works with these groups that litigate issues before the Supreme Court before her husband, Clarence Thomas. Federal law requires the disqualification of a Supreme Court justice in any proceeding in which the justice's impartiality might reasonably be questioned. And the Supreme Court's own code of conduct reiterates that Supreme Court justices should disqualify themselves in cases when there's reasonable doubt about impartiality. Despite serious questions about Justice Thomas's impartiality in numerous cases, he refuses to recuse himself. During the court's most recent term, he continued to hear cases related to the January 6th insurrection, despite Jenny Thomas, his wife's, personal involvement with efforts to overturn the 2020 election. And Justice Thomas's failure to recuse is not his only ethical failure related to his wife's activities. For years, Justice Thomas omitted his wife's income from the right-wing Heritage Foundation from his annual financial disclosure, despite having disclosed her income in some previous years. In other words, he wasn't even consistent. And as I mentioned earlier, Justice Thomas's ethical issues extend far beyond his wife's employment and advocacy. He's repeatedly violated the federal law by failing to report gifts and income from a wide range of sources in his financial disclosure. How do we know this about Justice Clarence Thomas? Because the Senate Judiciary Committee sent out subpoenas, and the subpoenas resulted in cooperation from some of the people who gave him these gifts. They gave us the details of what they provided in the past, and he failed to disclose over and over again. He's compounded that failure by repeatedly failing to recuse himself in cases involving the same individuals and groups lavishing these gifts upon him. I get it. They're sending these gifts to Clarence Thomas, who's sitting as a judge in cases that mean a lot to them monetarily. More than 12 years ago, I called on Chief Justice Roberts to adopt a binding code of conduct for all Supreme Court justices. 12 years ago. Since then, repeated ethical misconduct by Supreme Court justices have proven that an unenforceable code of conduct is absolutely worthless, and an enforceable one is essential to restoring public confidence. However, Chief Justice Roberts refuses to use his power to do so. What is he waiting for? I call on each and every Supreme Court justice. If you agree with Clarence Thomas, declare it, that you have no responsibility to disclose your gifts or to recuse yourself in cases where there's a conflict. But if you think you're fed up with the reputation of a court that lacks integrity and you want to do something about it, speak up publicly on behalf of the court and on behalf of the nation. We'll continue in Congress to do our part. but some leadership from Chief Justice Roberts and members of the court could sure make a difference. I yield the floor.
Majority Whip.
Madam President, I rise today in the Senate to pass the Defiance Act, a bipartisan bill that provides a remedy for victims of non-consensual sexual exploitation deep fakes. And I want to thank the Senate co-sponsors of this legislation. They include my ranking Republican member, Senator Lindsey Graham, the ranking member of the Judiciary Committee, as well as Senators Klobuchar, Hawley, King, and Lee. This bill is truly bipartisan. And I've been proud to partner with the New York Congresswoman Alexandria Ocasio-Cortez, who introduced this legislation in the House of Representatives with 4 Republican and 4 Democratic co-sponsors. As you can see in both the Senate and the House, this is a bipartisan measure, and when I describe it, you'll understand. Sadly, Congresswoman Ocasio-Cortez herself is a victim of what is known as explicit deep fakes. I commend her for her work and courage to create tools for victims in the fight against this despicable conduct. The spread of these deplorable deepfakes is like a fire burning out of control. What used to take extraordinary technological expertise and a lot of time can now be done with the push of a button. Countless apps can swap someone's face onto another person's body or can digitally remove someone's clothing. These apps are often advertised as harmless entertainment, but when explicit images are produced and shared without the consent of the person depicted, the harm is very real. The exploitation of young children, the exploitation of women is really the price that's being paid for this. Imagine losing control over your own likeness and identity. Imagine how powerless victims feel when they cannot remove the illicit content, cannot prevent it from being reproduced, and cannot prevent new images from being created. The negative consequences to the victims can be profound. Victims may draw into silence themselves by withdrawing from online spaces and public discourse as a protective measure. They may endure threats to their employment, education, or reputation, or suffer additional criminal activity such as extortion and stalking. Some experience depression, anxiety, and fear of being in public, and in the worst case scenario, victims are driven to suicide. Representative Ocasio-Cortez recently described her own reaction to being depicted in sexual deepfakes without her consent. She said, and I quote, "There's a shock to seeing images of yourself that someone could think are real." She described how it resurfaced trauma and haunts her thoughts. Once these deepfakes are seen, they cannot be unseen. As she put it, quote, "Deepfakes are a way of digitizing violent humiliation against other people." Prominent women are often the target of non-consensual sexually explicit deepfakes. Singers, actors, politicians alike. You cannot escape the conclusion that these images are intended to diminish and shame women. But sadly, the victims can be anyone. There are many distressing reports this year of middle school and high school struggling to respond to the spread of sexually explicit deepfakes of students. In March of this year, at least 22 students at the Richmond Burton High School in McHenry County in my home state of Illinois learned they were depicted in deepfakes circulating online. One of the images was a doctored version of a photo of 2 female students taken at the school prom. The perpetrator digitally removed their clothes to make it appear that they were unclothed. The prom is supposed to be a joyous rite of passage for teenagers, a happy memory they keep for the rest of their lives. And now that memory has been stolen from these 2 young women. Sadly, we are seeing an explosion of images like these. One researcher found that the number of non-consensual, pornographic, deep life videos available online has increased 9-fold in the last 5 years. Such videos have been viewed almost 4 billion times. 4 billion times. Monthly traffic to the top 20 deepfake sites increased by 285% from July 2020 to July 2023. Search engines directed 25 million visits to the top 5 most popular deepfake sites in July 2023 alone. And tragically, under the law now, the victims have no legal remedy. Time and again, victims are told nothing can be done to help them because existing laws simply do not apply to deepfakes. This is not just a gap in the law. It's an omission that shows a blatant disregard for the trauma of children, women, and girls who are victimized by this crime. But this Defiance Act will change that. It will give the victims a day in court. Once this bill is signed into law, victims finally will have the ability to hold civilly liable those who produce, disclose, solicit, or possess sexually explicit deepfakes, while knowingly or recklessly disregarding that the person depicted did not consent to the conduct. I'm proud that we've collaborated with the survivors' advocates on this bill. They have lived experience and leadership and have shaped this bill. This bill was carefully crafted to comply with the First Amendment. As the Center for Democracy and Technology wrote in their letter endorsing the bill, it is constitutional because it addresses, quote, a uniquely compelling problem with a narrowly tailored solution. In addition to the CDT, the Defiance Act is supported by the National Center on Sexual Exploitation, the Sexual Violence Prevention Association, the National Women's Law Center, My Image, My Choice, PACT, Rights for Girls, and many others. Congress has waited too long to act. Can you imagine in your own family if it was your wife, your daughter, your niece, or some young woman that you love who was exploited this way, who had to see these images and try to erase them from their minds, who realize that they have no power now under the law, no power to protect themselves. They are helplessly exploited, and their lives can be changed for the worse. We have waited far too long to act. This is a bipartisan measure in both the House and the Senate. It is past time to give victims of non-consensual sexual exploitation and explicit deepfakes the tools they need to fight back. Madam President, notwithstanding Rule 22, as if in legislative session, I ask unanimous consent that the Committee on Judiciary be discharged from further consideration of S3696, the Disrupt Explicit Forged Images and Non-Consensual Edits Act of 2024, and the Senate proceed to its immediate consideration. I further ask consent that the Durbin-Grassley substitute amendment at the desk be agreed to. The bill is amended be considered read a third time and passed, and the motions to reconsider be considered made and laid upon the table.
Is there an objection? Wyoming.
Reserving the right to object, I strongly support the intent behind this legislation. We must combat the deeply harmful practice of non-consensual deepfake pornography. It is as serious as the gentleman from Illinois just described. But I'm troubled that this bill, as currently drafted, is overly broad in scope. The expansive definitions and wide net of liability in this bill could lead to unintended consequences that stifle American technological innovation and development. By extending liability to third-party platforms that may unknowingly host this illicit content, I worry this bill places an untenable burden on online services to constantly police user-generated posts. Even platforms making good faith efforts to remove illegal deepfakes could become inundated with frivolous litigation. A more prudent approach would be to tailor legislation to focus on publishers and knowing distributors. And such legislation exists. It is the Cruz-Klobuchar bill. We must ensure that in our noble efforts to prevent abuse, we do not inadvertently impose overbroad restrictions and spur excessive lawsuits that would chill the development of American emerging technologies. I stand ready to work with my colleagues to find this crucial balance. For these reasons, I object. And I yield back.
Objection is heard.
Madam President,
Majority Whip.
I'm disappointed, seriously disappointed. When we talk about these young women and young children being exploited and have bipartisan legislation before both the House and the Senate to deal with it, it is important that it be characterized properly. First, there is no liability under this proposed law for tech platforms, despite what was said by the gentlelady from Wyoming. And secondly, the idea that the people would suffer civil liability here when they didn't know what was going on. Listen to the language of this bill. Victims have the ability to hold civilly liable those who produce, disclose, solicit, possess sexually explicit deep fakes while knowingly or recklessly disregarding the person that depicted did not consent to the conduct. The two major issues raised by the gentlelady from Wyoming, the senator from Wyoming, are both addressed in this bipartisan measure. There are people who will shake their heads and say, can't the Senate even address this issue, the sexual exploitation of children and young girls and attempts to ruin their lives? Can't they even agree on a bipartisan basis to come up with an answer? We did. We have a bill that does it, and it's been stopped. We're not going to stop our efforts, Madam President. This is a cause worth fighting for, and we're going to really appeal to those across America who believe as we do. I yield the floor.
Majority Whip.
Madam President, for more than a year, the Supreme Court has been embroiled in an ethical crisis of its own design. Story after story about ethical misconduct by sitting Supreme Court justices has led the news for months. For decades, however, Justice Clarence Thomas has accepted lavish gifts and luxury trips from a gaggle of fawning billionaires. The total dollar value of these gifts is in the millions. One Supreme Court justice, millions of dollars worth of gifts. Justice Alito, as well, went on a luxury fishing trip that should have cost him over $100,000. But it didn't cost him a dime because the trip was funded by a billionaire and organized by right-wing kingpin Leonard Leo. Both Justice Thomas and Justice Alito have failed to disclose gifts they have accepted, in clear violation of financial disclosure requirements under federal law. But it isn't only this shameless conduct that has cast a dark shadow over the court. Time and again, these justices' actions have cast doubt on their impartiality in cases before the court. Last summer, Justice Alito sat for an interview conducted in part by an attorney with a case before the court. In that interview, Justice Alito went so far as to publicly state that Congress has no authority to regulate the Supreme Court. By doing so, he made it clear that he had already reached a conclusion about the constitutionality of legislation that Congress was considering on the issue, legislation that will be before this body today and that could someday come before the court. More recently, we learned that the flags that were associated with the January 6th insurrection and far right were displayed outside Justice Alito's home. This happened even as the court considered cases related to the 2020 presidential election and the insurrectionist attack on the United States Capitol. Justice Thomas also continues to hear cases related to January 6 attacks, despite his wife's involvement with efforts to overturn the 2020 election. For years, Justice Thomas served as a fundraising draw at the Koch Political Network's annual events. This is the same network that bankrolled another case currently before the court. Federal law requires the disqualification of a Supreme Court justice in any proceeding in which the justice's impartiality might reasonably be questioned. And the Supreme Court's own code of conduct reiterates that justices should disqualify themselves in cases where there is reasonable doubt about their impartiality. But despite serious questions about the impartiality of Justice Alito and Justice Thomas in numerous cases, they have refused to recuse themselves from these cases. The ethics crisis at the Supreme Court, the highest court in the land, is unacceptable. It is unsustainable, and it's unworthy of the highest court in the land. Our faith in the character and impartiality of our judges is essential to the functioning of our legal system and our constitutional form of government. But that faith requires judges, especially Supreme Court justices, to conduct themselves in a way that inspires public confidence. The justices should serve as models for every other judge in America, Instead, they are serving as prime examples for why a binding code of conduct is desperately needed for the Supreme Court. The ethics crisis at the court stems in large part from the fact that 9 justices on the court are the only federal officials not bound by an enforceable code of conduct. The only federal officials not bound by an enforceable code of conduct. More than 12 years ago, I first asked Chief Justice Roberts to adopt a binding code of conduct for all Supreme Court justices. In November of last year, for the first time in its 235-year history, the Supreme Court adopted an ineffective code of conduct for its justices. But the new code does not reform the court's ethics rules in any meaningful way and does not include an enforcement mechanism to address violations of the code. As the court conceded in the statement accompanying the code of conduct's release, it said, quote, "The code largely represents a codification of principles that have long regarded as governing our conduct." In other words, this so-called new code did not raise the ethical standards to which the justices would be held. It simply tried to paper over the failed practices of the past. The court can address these issues itself. The court could have issued a stronger code of conduct in the first place. It could revise its own code of conduct today. But Chief Justice Roberts repeatedly refuses to use his authority and power to implement a binding code of conduct for the Supreme Court. Until he does, Congress will continue our legislative efforts. Last year, the Judiciary Committee, which I chair, reported to the Senate floor the Supreme Court Ethics, Recusal, and Transparency Act, the bill, which was led by Senator Whitehouse, who is on the floor, and which I am co-sponsoring, would require the Supreme Court to adopt an enforceable code of conduct and add new recusal and transparency requirements binding on the justices. It would be a real code of conduct. Importantly, this legislation's ethical and recusal requirements would apply to equally to every justice on the Supreme Court, regardless of the party of the president who appointed them. This should not be a partisan issue. An enforceable code of conduct would be a good thing for the court and for our country. It is essential to ensuring the American people have confidence in the ethical conduct of the Supreme Court, and it's essential to restoring the court's reputation. The highest court in the land should not and cannot have the lowest ethical standards. That is why I support this legislation and why I urge my colleagues to join me. And, Madam President, notwithstanding Rule 22, and as if in legislative session, I ask unanimous consent the Senate proceed to the immediate consideration of calendar number 199, S359, Supreme Court Ethics, Recusal, and Transparency Act of 2023. I further ask that the committee report substitute amendment be agreed to, the bill as amended be considered read a third time and passed, and that the motion to reconsider be considered made and laid upon the table with no intervening action or debate.
Is there an objection?
Madam President,
Senator from South Carolina.
reserving the right to object. Let's be clear, this is not about improving the court. This is about undermining the court. We have 3 branches of government here. We've got the legislative, executive, and judicial branch. This would be an unconstitutional overreach. This would undermine the court's ability to operate effectively. And it's been a continued effort by our friends on the Democratic side to undermine a court they don't like. Here's what the Supreme Court has done. In April of 2023, all 9 justices signed a statement on ethics, principles, and practices specifying the ethics, principles, and practices they follow. In March 2023, the Committee on Financial Disclosures formally amended the personal hospitality regulations in a manner that now requires more complete disclosure. In November of 2023, all 9 justices promulgated a code of conduct. The court is taking these problems seriously. The question is, what are we up to here? We're trying not to empower the court or reform the court. We're trying to attack it right at the end of a term. I remember very well when the majority leader, Senator Schumer, went to the court and said, right in front of the court itself, I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price. You won't know what hit you, and if you go forward with these awful decisions. It's really about the way the court decides cases that our colleagues on the other side really don't like. So all I would say is that there are provisions in this bill that should bother anybody that cares about an independent judiciary. Judicial investigative panels in Section 2 of this bill are made up of lower court judges who would actually preside over their bosses. There is one Supreme Court here. This is unnerving to have a group of lower court judges basically having an investigative panel the ability to investigate the Supreme Court, the constitutionally designated Supreme Court. Recusal, that's been up to the individual justices since the court's founding. This bill would create a panel of judges to decide when a Supreme Court justice should be recused. Again, that just puts the court in, I think, disarray and fundamentally assaults the one Supreme Court we have. All I can say is that Section 7, where you have to have disclosures of amicus briefs, would make it very hard for certain people to register their opinions about a particular matter before the court, because they could get destroyed by the media, they could get destroyed by special interest groups, and I think that chills out the ability for people to petition the court apart from politics. So my hope is that not only will we stop this exercise now, we'll stop it forever. With that said, I withhold my objection at this time.
Madam President.
Is there an objection?
Madam President, reserving the right to object.
Senator from Louisiana.
Madam President, reserving the right to object. And with all the respect I can muster for Senator Durbin, and I mean that, Dick, I do not believe that most of my colleagues think this bill is about ethics. This bill is about abortion. In June of 2022, the United States Supreme Court decided the Dobbs case. It returned the issue of abortion to the American people through their states. While the Supreme Court was deliberating that case, my colleague and my friend, Senator Schumer, went over to the Supreme Court. And on the steps of the Supreme Court building, I was there. I remember it like it was yesterday. This is what Senator Schumer said. I quote, "I want to tell you, Gorsuch, I want to tell you, Kavanaugh, not Justice Gorsuch, not Justice Kavanaugh. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you," Senator Schumer said, "if you go forward with these awful decisions." Close quote. What we're seeing today with this legislation, in my opinion, but most senators agree with me, is part of the promised whirlwind. And I do not believe that we should try to undermine the integrity of the institution of the Supreme Court of the United States because we're unhappy with one of its opinions. I will withhold my objection at this time, Madam President, to allow my friend Senator Lee to speak.
Is there an objection?
Madam President.
Senator from Utah.
Reserving the right to object. The United States of America has benefited for nearly 2.5 centuries from having one of the world's best, most objective judicial systems in the entire world. While no system run by fallible mortal human beings can be described as perfect, ours is as good a system as has ever existed in the world, as certainly good as any that exists in the world today. At the capstone of that is an entity that exists by virtue, by operation of the Constitution, the Supreme Court of the United States. And this solution, the solution that's being rammed through today, this is a solution in search of a problem that would itself create another problem for which there would be no solution. That problem would in turn one of our greatest strengths, an independent functioning judicial system, one that has preserved the rule of law in this country for nearly 2.5 centuries, into something of a more political animal. It's not what we want. It's not what the Constitution contemplates. It's not what we've benefited from. And why? We must ask the question, why? Is there any grave moral offense that's been committed? No. And is there any grave violation of law that's been committed? No. Is there any violation of law that's been committed at all? No, there is not. What we have here is something very, very cynical. And what we have is that people on the left have a couple of cases currently pending before the Supreme Court of the United States, cases that they're worried about the outcome, cases in which they're worried that certain justices might rule against them. And they have some justices they don't like. They have some justices that they worry are going to reject the bad arguments that they've made in those cases. And so rather than double down on making sure that their arguments are good and that they're persuasive and recognizing that they're not going to win all cases, they're threatening, they're intimidating the justices. It's not just a mountain out of a molehill. They're making a mountain out of nothing. And they're doing this specifically to harass, threaten, and intimidate certain members of the Supreme Court in order to influence the outcome of pending litigation. And make no mistake, that is what's going on here. They're trying to trigger more recusals of those justices they don't like. The legislation they're offering would create more problems in this, would make it easier for them to trigger more recusals. This is not a good outcome. This is a political effort to influence the resolution of pending litigation before the Supreme Court of the United States and to threaten justices that don't toe the woke line. So, Madam President, I withhold my objection at this moment.
Is there an objection?
Madam President.
Senator from Texas.
Madam President, reserving the right to object, I just want to briefly summarize the arguments that my able colleagues on this side of the aisle have made. An independent judiciary are the crown jewels of our democracy. And what do I mean by that? We have the political branches of government. We've got the White House, popularly elected president through the Electoral College. We've got individual senators elected by the various states. And then we've got the House of Representatives. Those are all political bodies. The judiciary, created by the Constitution, Supreme Court specifically, was designed to be a check on the abuses of power by the political branches of government and to hold up the Constitution as a supreme law of the land. That was Marbury versus Madison by Chief Justice Marshall in 1804, I believe. So the Constitution is the supreme law of the land. It's not the political branches. And I think in recent years, we have seen every institution in Washington, D.C. corrupted in one way or the other by the politicalization of previously revered institutions. And I'm talking specifically about the FBI and the use of a opposition research by a presidential candidate against a successful presidential candidate, President Trump, and then the FBI director say his mission in life was to see a special counsel appointed, which it was for 2 years, Robert Mueller, who found no basis upon which to bring any charges. Unfortunately, the American people feel like there's a two-tiered system of justice in this country. And that justice system, which has been the crown jewel of our system, has been corrupted by politics. And now our colleagues want to use that same corruption by politics of the independent judiciary and the Supreme Court of the United States. That may not be their intention. Maybe it is. They want the Supreme Court to become subservient to the Congress, which is anathema to the constitutional order created by the framers. This effort lays bare an effort by our Democratic colleagues to control an entire branch of government. There's been bills filed by the senator from Massachusetts and others to pack the Supreme Court. Fortunately, they haven't gone anywhere. But as our colleague knows, this is, and admitted yesterday, the chairman of the Judiciary Committee, this is nothing but a political exercise, and it needs to end now. For these reasons, I would oppose this legislation and withhold my objection so the distinguished ranking member from the Judiciary Committee can speak.
Is there an objection? Objection is heard. Majority Whip.
Before yielding to the senator from Rhode Island, one of the critics of this proposal said it was a solution in search of a problem. The Republican side of the aisle believes, obviously, that for one Supreme Court justice to accept lavish gifts and luxury trips from billionaires to the tune of millions of dollars, and for another Supreme Court justice to take an undisclosed trip, fishing trip, at the cost of $100,000 is business as usual at the Supreme Court. The American people, I'm sure, will disagree. I yield the floor. I'm sorry. One last thing. I ask unanimous consent the confirmation vote on the Chang nomination be at 11:30 a.m. tomorrow, Thursday, June 13th. Further, that following disposition of that nomination, the Senate resume legislative session, that the cloture motion with respect to the motion to proceed to calendar 415 as 4445 ripen at 1:45 p.m. The mandatory quorum call be waived.
Is there an objection? Without objection. Senator from Rhode Island.
First, let me thank the chairman of our committee for attempting to bring this bill to the floor and to get us on it, even though the Republicans have objected to Supreme Court ethics. It's important for us to continue to make the effort because the American people understand that there's something gone very wrong at the Supreme Court. The objections that we just heard amounted to a long excursion through a great variety of topics, through abortion, through past FBI investigations, through allegations about a two-tiered system of justice, through wokeness, through things we all agree on, like separation of powers and an independent judiciary. I think it would be helpful to actually come into focus on what we're actually talking about here, because most of what was said in opposition to this bill is completely irrelevant to what we are seeking to achieve. We all accept the doctrine of separation of powers. Senator Blumenthal, who is here, is an expert in the subject. He's argued more cases in the Supreme Court than any other senator. To be clear, our bill does not make the Supreme Court subservient to Congress in any respect. The bill obliges the judicial branch of government to create its own ethics enforcement mechanism that will be run within the judicial branch of government by the judicial branch of government. There simply is not a separation of powers concern when the judicial branch of government runs an ethics program for the judicial branch of government that is administered within the judicial branch of government. It just ain't so, Madam President. The existing state of affairs is that the ethics requirements that apply to the justices of the Supreme Court, first related to recusal, and second related to disclosure of gifts, are laws passed by Congress. And the enforcement, particularly of the disclosure requirements, is done by the Judicial Conference. The Judicial Conference is a body established by Congress. When Harlan Crow first started giving free yacht and jet travel secretly to Clarence Thomas, that question was taken up by the Judicial Conference a decade ago. Did the justices complain that the Judicial Conference was investigating Justice Thomas and his disclosures? No, of course not, because the argument would make no sense. So to hear it here on the Senate floor is a bit disappointing. Right now, the Judicial Conference investigates and can sanction or refer for further investigation justices of the Supreme Court. We are trying to fix three really simple problems. One is fact-finding. Fact-finding ought not to be an issue in dispute. Every member of government in the United States who is subject to any kind of supervision or ethics requirement, which is everybody, has a process whereby the actual facts are found of what went wrong. Hell, even the President of the United States had to sit for a fact-finding interview about the documents in his garage. It's only 9 people in the entirety of the United States government who think that they have no obligation to do any fact-finding. And that's pretty dangerous because we just saw Justice Alito offer facts, a description about what went on behind his family flying MAGA battle flags over their houses that has been proven false by information that is incontestable. Police reports with dates showed that he got the order of things wrong. COVID showed that it couldn't possibly have been a school bus stop. So you have erroneous facts offered by Supreme Court justices with no method to review them, or they completely ignore the facts. Justice Thomas has refused to ever say a word about what he knew about his wife's engagement in the insurrection while he was adjudicating the rights of those investigating the insurrection. There's nobody else in the world where somebody doesn't come in and say, "Sir, we have a complaint about your conduct and we're going to need to take a statement from you. This won't take long. I'm going to ask you some questions. You give your answers. At the end, we'll ask you to review and sign your statement." Nothing difficult about that. Nothing against the separation of powers about that. Nothing that Chief Justice Roberts couldn't require right now about that. He could have Supreme Court staff attorneys conduct exactly that kind of work right now, as the chairman has repeatedly pointed out. Fact-finding is a really basic elemental proposition of our American judicial process, and it applies everywhere. It makes no sense for the body ultimately responsible for policing proper judicial process in the United States to not allow itself to participate in that most elemental and fundamental task of there being actual fact-finding. The second is a principle so old it's in Latin, for Pete's sake. Nemo judex in sua causa. No one should judge their own case. That's pretty easy to understand. And yet we let these justices, alone in the United States, nobody else, get to be the judges of their own ethics. And obviously they have failed to measure up. And the third issue is transparency, disclosure. We know perfectly well that the justices have failed at their disclosure obligations. And they can't keep their stories straight about meeting their disclosure obligations. We just had Justice Thomas go back into his previous disclosures to correct them and tell the world and the Judicial Conference, which was reviewing this, that his failure to file was an accidental error. It was, quote, inadvertent. But earlier he'd said about the same gifts from the same billionaire, oh, those don't have to be reported. That was personal hospitality from a dear friend. Well, which is it? Is it personal hospitality that doesn't have to be reported? Or is it something that you knew perfectly well you should have reported, and now you're going back and cleaning up an error that you're claiming is inadvertent? The disclosure mistakes are inexcusable on their face. Federal officials who commit far less in the way of disclosure mistakes have actually been prosecuted as felons, as misdemeanants under the criminal law for those similar disclosure violations. So we need to get this right. All it requires is fact-finding and an independent voice, so it's not nemo judex. You're not judging your own cause. Those are really basic principles. That's all we're trying to do. It would be done by judges within the judiciary. There is no separation of powers issue. That is a complete canard. And I'll close by saying that the Judicial Conference has been helping us in all of this. The Judicial Conference has just blown up Justice Scalia's trick, which was to solicit through intermediaries free vacations from resort owners, and then when the resort owner invited him with a personal invitation, he would pretend that that was personal hospitality because it was a personal invitation, even if he'd never met the resort owner. That is a preposterous reading of the personal hospitality exemption. And it's not just me saying that. The judges of the Judicial Conference said, you are right. That is preposterous. That is ridiculous. We are clarifying the rule that that is not acceptable. And he had done it 60 times. He was a vacation-taking fiend, my Lord. So the idea that you can trust a Supreme Court justice with no independent review, no fact-finding, each the judge in his own cause, to follow the rules, has been blown to smithereens by the conduct of the Supreme Court justices themselves. As our chairman is fond of saying, this is a crisis in ethics at the Supreme Court that the Supreme Court itself has created. It is a crisis in ethics at the Supreme Court that Justice Roberts himself and the Judicial Conference can solve. But if they're not going to do it, we're going to do what we did before when we set up the Judicial Conference, when we set up the recusal laws, when we set up the disclosure laws. Set up the system and let the judiciary enforce it. I yield the floor.
Mr. President. Thank you, Mr. President. Let me first ask permission, if there's no objection, that Amanda Padgett, Senator Merkley's intern, be granted the privilege of the floor for the balance of the day. Second, I want to thank my colleagues, Senator Durbin and Senator Whitehouse. I've been proud to be part of their team working for the most minimal kind of ethical standards for the highest court in the land. Right now, that court has no enforceable code of conduct, unlike any other court in the federal system, unlike any other branch of government. It is so elemental as a matter of simple ethical conduct and appearance. The Supreme Court has squandered its almost mystical authority, its unique power in the federal government. In a sense, that power was not envisioned by the founders. The idea of judicial review came after the Constitution was written. We can thank Justice Marshall for that idea that the Supreme Court can literally strike down what we do here. It's the most powerful branch of government, not the least dangerous, but the most powerful. And think of it for a moment. In a democratic republic, it's unelected. It has life tenure. Nobody can tell a justice, you're too old to do this stuff anymore. It is the most anti-democratic or undemocratic institution in a democratic system of government that you could possibly imagine. And so its power is really dependent on its adherence to standards of integrity that gain respect and credibility. It has no armies, it has no police force. People following those orders that it issues are because its wisdom and integrity have gained respect. This Supreme Court is different than any other we've seen. And it's not just two members of the Supreme Court, because it is the institution as a whole that's responsible. And it is the Chief Justice of the court that is most responsible. And so I ask Chief Justice Roberts, please endorse this legislation, not just for the sake of your legacy. We know Chief Justice Roberts cares about his legacy, but for the sake of the court. This court is doing things, justices are committing errors of extraordinary misjudgment, not to mention corrupt taking of gifts and trips and all the rest, that are, to use my colleagues' words, blowing to smithereens the credibility and trust that this court needs. It needs it for its decisions to be followed and respected. What we're doing here is very simply saying to the court, you must have a code of conduct that's enforceable. We're not telling them what to do. We're not telling them to decide a case in one way or another. We're not interfering with their docket. We're not in any way affecting the substantive decisions of the United States Supreme Court. It is simply how they conduct themselves as public officials, whether they take gifts, whether they go on trips paid by somebody else, whether they accept tuition grants. It's common sense. You don't need to be a law school graduate to understand it. In fact, this idea is more comprehensible and more impactful to the folks who go to work every day, and nobody gives them college tuitions, nobody takes them on private jets to islands that cost thousands of dollars to reach. To the ordinary American, the everyday American, this legislation not only makes sense, I think most people assume there already is legislation like the one we're debating today. So I'm not going to belabor the specific provisions of this bill. I believe that we're going to have to go farther. I think there ought to be an inspector general for the courts as a part of the judicial conference, just like there is in other government entities. I think there has to be court reform that casts light on the shadow docket. There are a series of reforms, and some are a lot more draconian in their scope. But this act is simple in requiring disclosure rules for gifts, travel, and income that are at least as strict as those we comply with here in Congress, a code of ethics, recusal, and Alito and Thomas should have recused themselves long ago from decisions involving Donald Trump. This comprehensive judicial ethics legislation is long overdue, and my biggest regret as I stand on the floor of the Senate today is that it is not bipartisan, because it should be. I've argued 4 cases in the United States Supreme Court. I've been a law clerk there. I have immense respect, unshakable respect for the institution, the institution. I have reverence for what it reflects in America. And sadly, the court has inflicted wounds on itself that will be difficult, and my fear is impossible to repair. But this measure will at least begin that process. Thank you, and I yield the floor.
Mr. President,
Senator from Vermont.
My colleagues on the Republican side have made the assertion that this legislation would interfere with the independence of the judiciary. That's a serious assertion, and it deserves to be respected and responded to. The judiciary is an absolutely vital branch of government that is independent. It is independent in the process by which it makes decisions that come before it for its decision. That's where it is independent. In as much as I disagree with many of the decisions of the Supreme Court, that court has the right, without interference from Congress, to make the decisions it makes. And there is absolutely nothing in this legislation that interferes with the judicial power that the court alone exercises in considering cases and making decisions. There is absolutely nothing. And to suggest by our colleagues that this legislation would do that is that flat out wrong. What this legislation responds to is the conduct of individual justices that is, frankly, pretty shocking. You get a call, hey, there's a yacht that needs you on board. Hey, don't worry about how to get there. We've got a private plane. Hey, don't worry. If you didn't come, that seat would be unoccupied. And the justice actually does it. They get on that plane and go, and they get on the yacht. Hey, by the way, we're having a fishing trip. It's in Alaska. It's really cool. Let's go. There's an empty seat. Why don't you come? It's worth $100,000, but it doesn't have to be reported. When we talk about a code of ethics for the Supreme Court, and these are some of the examples of why it's needed, my constituents in Vermont say, Peter, what are you talking about, a code of ethics? They can get away with that? They can do that? They can take this free trip? It's really, really shocking. And my colleague from Connecticut said it right. The Chief Justice has not only the authority, but the responsibility to deal with the problems of behavior in his own court, and he's not doing it. He is not doing it. And another point that my colleagues make that I'm in 100% agreement with, we need a Supreme Court that has the credibility and confidence of this country, because we face very difficult decisions that are quite contentious and divide America. And when those are contested and they go to the court, and the court renders a decision that all of us have to abide by, whether we were on the winning side or the losing side, we absolutely must have a court that has credibility. And the credibility has to be, if it's going to be enhanced by the court, by following codes of conduct, by giving American people confidence that they're on the level. They're not doing it. These free trips, these private planes, the private yachts, that is just self-serving and frankly gross. Who has the opportunity to take those trips in the job they do? By the way, this is an important job they have, but it's a job. And you do your job, you get your paycheck, you show up for work, you treat the people you work with decently. But you don't have some expectation because of the particular job you have, you get free special trips just because you are, quote, important. That's not part of the deal here. That's not constitutionally protected. That's not anything to do with the independence of the judiciary. That is just about venal, self-serving conduct by people who happen to have a lifetime appointment. And the other point here that is really truly shocking and astonishing, we've got over 800 judges. Circuit court, appellate court, bankruptcy judges. They have a code of conduct. They can't do this. There's only 9 folks that can do it. and they're on the Supreme Court. They should have the highest standards that apply to them. Self-imposed. They have no standards. This is the Supreme Court eroding the confidence the public, all of us, whichever side of the decision we're on, are entitled to have from the people who have that lifetime appointment, and they are squandering it. They are turning a blind eye to the needs of the people that they serve. So this ethics legislation is unfortunately necessary because the Supreme Court will not do what it has the responsibility to do. The Chief Justice of the United States Supreme Court will not face down colleagues on that court who are just disregarding normal rules of decency. So I say to the chair and my colleagues, and I say to my colleagues on the other side of the aisle, all of us should be doing everything we can to restore confidence in the judiciary. This is step one. I yield back.
Morgan. Mr. President, this last weekend, I held 6 town halls in 6 rural counties, and in town hall after town hall, people kept asking, what happened to the Supreme Court? How did it become so corrupt? Why hasn't the Chief Justice reined it in? Well, these 6 town halls, these were not an anomaly. I've held 25 town halls previous to this weekend, this year, and again, in community after community, people want to know, how has it occurred that the Supreme Court has squandered its integrity? Well, they are alarmed about the members of the court taking special favors, gifts worth millions of dollars. Wait, did I say millions of dollars? Surely thousands, not millions. Yes, the justices have taken gifts worth millions of dollars. The Fix the Court group has documented the gifts since over the last 20 years, 2004, valued at $6,592,657 to 18 current and former justices of the court. One justice alone, Justice Thomas, taking gifts valued, 193 gifts, valued at over $4 million. Justice Alito accepting gifts valued at over $170,000. How is it possible that the highest court in the land has sunk to such a low level? Those gifts, $300,000 luxury RVs, fishing trips to Alaska, super yacht trips to Russia and the Greek Isles and Indonesia. Well, the court did respond. They responded earlier this year by releasing their own code of ethics, a publicity stunt, a code of ethics with no teeth, a code of ethics with no enforcement, a code of ethics that completely fails to address the obvious conflicts of interest and breaches of public trust. Justice may be blind, but we cannot turn a blind eye to these injustices. Congress and the court are separate but equal branches of power. And it's our job to check and balance one another. And the Supreme Court certainly should have issued for itself a compelling code of ethics, but it has not. And so the balance is for us to do it for them. It is our responsibility to do it, to protect them from their own common instincts of taking gifts that they should never touch. Well, the Supreme Court Ethics, Recusal, and Transparency Act will require a strong and enforceable code of ethics for the Supreme Court so that all Americans can trust that cases between the court are being decided impartially based on the facts of the case, the letter of the law, and the principles of our We the People Constitution, not based on relationships forged on super yachts and fishing trips and gifts of $300,000 RVs. Who here if you were called to defend yourself in a suit in court, would feel like you're getting a fair hearing if the party that brought the suit against you has been giving thousands or millions of dollars to the judge hearing the case. Who here would think that you're getting a fair hearing? No one. We all understand that this is corruption. We all understand that this is a horrific conflict of interest. And we all understand it's unacceptable, and the court has failed in its responsibilities to the American people. The Supreme Court, it has to stand for the interests of the people, not the powerful. Think of these life-altering cases being decided by the court on reproductive rights, on worker rights, on voting rights, on environmental rights, on LGBTQ rights. So the American people need transparency. They need legitimacy. They need accountability. We, the American people, need justice unpolluted by gifts from parties having issues before the court. So I urge my colleagues, let's all stand together, all 100 of us, and stand up for the integrity of the court and pass the Supreme Court Ethics, Recusal, and Transparency Act. It is my pleasure to yield to my colleague from the state of Delaware, Senator Coons.
Mr. President,
Senator from Delaware.
Mr. President, I rise to urge this body to reconsider the objection that was just made by my colleagues. The rule of law, the system of ordered liberty, for which so many Americans have served and sacrificed at home and abroad, is a fragile thing, is at times a mere tissue, and it is held together by the confidence of our people in the ethics and integrity of those whom they elect or who are appointed, nominated, confirmed to serve them. We've seen a number of challenging chapters around ethics and integrity in public service recently, but tonight we're on this floor to speak about our Supreme Court and a simply shocking series of revelations about ways in which justices have accepted over years huge amounts of gifts. The suggestion's been made by a number of my colleagues that this is just Democrats, that this is just a partisan attack on a few justices to try and roll back or undermine decisions they've made we dislike or their legitimacy. Well, I can give you a compelling counterpoint. My friend and colleague Senator Cornyn and I, seeing a whole series of stories in the Wall Street Journal in 2021 that revealed that there were dozens of federal judges who had stock holdings in companies where issues before them implicated the value of that company, moved us to introduce the bipartisan Courthouse Ethics and Transparency Act. Your typical bill takes 6, 7, 8 years to become law here in the Senate. This one moved faster than almost any other. And on the Senate Judiciary Committee and here on the floor of the Senate, nobody argued that the Supreme Court needed to be above it all. Nobody argued that the justices of the Supreme Court shouldn't be required to disclose their stock holdings and be accountable for their failures to recuse or disclose. In fact, that bill passed unanimously. Why then is this one not similarly situated? Every federal judge is subject to a binding code of ethics. Every senator, virtually every federal employee of a senior decision-making role is bound by a code of ethics. That's how the American people know that if there is some slight or fault, some self-dealing, or some action that creates the appearance of impropriety, that action will be taken. And after months and months and months of reports of misconduct, failure to disclose, questionable conduct by a justice or two of the Supreme Court, a recent poll by Marquette shows that a majority of the American people have lost faith in this institution and no longer have confidence in the political independence and the ethics of our Supreme Court. Mr. Chief Justice, I hope you listen or watch. We believe you to be concerned about the legitimacy of this important institution. The Supreme Court is the only federal court not bound by a code of conduct that is enforceable, and where these disclosures and their consequences cannot be acted upon. The highest court in our land should not have the lowest ethical standards. And we should take a vote on this bill, the Supreme Court Ethics, Recusal, and Transparency Act. It should not be controversial or partisan. This isn't about attacking one justice or another. As someone who clerked for a federal judge, as someone who's chief counsel, clerked for a federal judge, many of us are lawyers in this body and clerked for federal judges. We know the importance of having an independent judiciary, of having a nonpartisan judiciary. And the most powerful court in the land is the Supreme Court. When it issued landmark decisions unanimously, it moved the arc of history. Today, it issues decision after decision that are 5-4 and that are producing challenging secondary waves in our body politic. If the Supreme Court is to hold the role that our framers intended, it must do so above reproach. That is not where we are today. Our Supreme Court must make itself accountable to the American people. We shouldn't read disclosure after disclosure in the press to learn about the conduct of the justices. Just a few moments ago, earlier this evening, along with the rest of the Delaware delegation, I had the honor of meeting with the newest nominees to our nation's Service Academy. Young men and women who are raising their right hand and volunteering to serve our nation, who will be granted the opportunity at a free education, in exchange for which they sign on the dotted line and agree to go serve our nation at home and abroad, and to defend our nation and our Constitution from all enemies, foreign and domestic. I've just completed a trip to the South Pacific where I visited Manila, and there is a World War II cemetery. It includes crosses marking the graves of 17,000 Americans who served and sacrificed in the convulsion that was the Second World War. Those crosses do not mark on them Democrat or Republican. The freedom for which they fought, the system of justice, the rule of law, the Constitution for which they took up arms against Imperial Japan and worked so tirelessly alongside our allies to free a world under assault from fascism and imperialism, did not do so based on a sense of partisan principles, but out of a commitment to our nation. We should honor those who served and sacrificed in a generation or two ago, and those who are willing to serve and sacrifice today going forward, by restoring ethics and transparency to the United States Supreme Court. They have cast a shameful shadow, not just the appearance of impropriety, but a genuine conflict. It can be resolved. We must help them take the action they should take and resolve it. We should pass this bill. With that, Mr. President, I yield the floor and suggest the absence of a quorum.
Will the senator withhold his request? Will the senator